Hi all, welcome back to my lecture series on IPR, and we were discussing about patent, and in that patent section we were discussing about application process of patent. So far we discussed that eligible applicant is going to submit application with the patent office along with fi- provisional provisional specification document or complete specification document. Once the document is submitted to a authority or a patent office or a patent controller, so the next step is publication of application. So what does it mean? Publication of application means it is making patent application available for public review. So public can go through that, and if they have any objections, they can raise against that patent application. Okay, so but when is that the publication is going to happen? The publication is going to happen once the document is submitted, submission of document. After that, there is a prescribed time, say it is prescribed time in the act. Based on that prescribed time, once the prescribed time is over, the document will be open. It will be publication. It will be published, and then the public can review this. Okay, so after the prescribed time is over, then the publication will happen. But controller can put a hold on the publication in following three cases. First one, if there is a secrecy direction, if there is a direction from the government that the subject matter of invention should be put under secret, so in that case, controller can put on hold for the publication of application. The second case is if the invention topic is abandoned under subsection 1 of section 9, then also controller can put this on hold. The third one is as usual, like if applicant withdraws his application before the prescribed time, and in those cases, in these three cases, controller can put an hold on publication of a application. Okay, but only in case of secrecy, if the secrecy guidelines is ceased to operate, if the secrecy like government removes the control of that secrecy, in those cases, after the removal, the publication will be taken place. Okay, so this is all about publication of application. And next point is what exactly should be the content of publication. The publication should contain date of application, number of applications, and name and address of the applicant and an abstract. All these things should be made available to public to go through it. One important thing to remember here is once the applicant applies for a patent, applies, then controller will publish it after prescribed period. Once the publication happens, applicant will be having all the privileges like a patentee, as if he has got the patent. If anybody does the infringement or a misuse of that document and they created a duplicate version of it or something, so he can file proceedings for infringement. Okay, misuse of a innovation, right? Or a copying or piracy, whatever, right? All those things can be, the applicant will be having similar right and privileges of a patent holder. Okay, once the document is published, there should be the next step is a examination step. Okay, the application will go through the examination, the examiner will review and other thing. Okay, this examination will take place only when a interested person or applicant makes a request in the prescribed manner for the examination. So the examination process will be initiated only when applicant or any other interested person make a request for examination. Okay. If no one makes an application for examination, then it will be assumed that the application is withdrawn by the applicant. So from the date of application before the grant of patent, people should request for application. If in case if he withdraws it, then there is no need for application for examination. Otherwise, they have to submit it for examination. Once the document is submitted, document is published, and request for examination is raised, the next step is to review of the document, examination of the document, and then grant of the patent is a are the next step. The detailed steps are provided in section 12 to 21. Summary is here. Once the request for examination is received by the controller within the stipulated time, controller, what he will do is controller will assign this work to a examiner. So applicant submits application to controller for examination. So controller will assign this to or refer this to examiner. Who is examiner? Examiner he will study the uh, innovation thing, and then he will make a all historical review of the documents and then provides his report. What is that this report contains? He ensures that all the documents which are submitted are in accordance with the requirement of this particular act, Indian Patent Act of 1970. And the claim for innovation or a claim for patent is a lawful ground. So it does not contain any illegal aspects. And the entire result of the investigation made under section 13. So in the section 13, government has provided the examiner what all he should examine. What all he should examine? Is there any existing research on that? Whether they have used any biological material or whatever it is, right? Entire detailed analysis should be done. That is part of section 13 or any other matters related to the innovation. All these points will be part of examiner reports. What all will be part of examiner's report? Whether documents are in accordance with the act. The second one, the innovation claim is on lawful matter, lawful subject matter, and the detailed investigation report as per section 30, and any other matter related to the innovation. All these things will be part of examiner report. So once examiner gets the permission to review, he will do his study. He will do his study within a prescribed period. Say, for example, it will be given 60 days to him. So within 60 days, he will make a required study and then submit the final report to a controller. Once the examiner submits, controller can either accepts. Okay, he can accept it. Controller can accept it and proceed with granting a patent. That's the first point. Right? What are the powers of controller with respect to examiner report? So first and foremost, controller can accept without any objections and then proceed with granting a license or a granting a patent. If controller is not happy, he can refuse or he can require for amendment in the entire document in certain cases. Okay, if controller is not happy with the certain content or a certain part of the document, he can ask for amendment or he can also refuse it. If the controller, if the invention is the documents are for one or more invention, so in that case, controller can ask for two or more different applications also. Very simple points. These are very simple points here. So if controller feels that if the innovation is for multiple uh, aspects, so he can ask for multiple documentations. And so controller can grant the patent based on the review and recommendation. provided that there is no objections. Okay. If it is a case of potential infringement, what does it mean? Uh, the documents which are submitted, it is like a copying from an other innovations from other countries, or it might be processes which are practiced in India from the long time, but they have documented and presented it. If it is a potential infringement, then controller can initiate inquiry. So these all are the powers of controller once the examiner submits the report. Clear, guys? And if a patentee asks for the ownership change, like, okay, if patentee says that uh, I'm transferring all the rights to some other party, so then it can be substituted. So guys, these all are the powers of the controller. The first one is he can simply accept it. He can simply accept it. The second one is he can refuse, or he can also ask for amended document. And the third one is if it requires multiple applications, then he can ask for multiple applications. And the fourth one is if everything is fine, he can grant a patent. And the fifth one is if there is a potential infringement, then he can initiate an inquiry. And finally, if there is a request by patentee for a substitute of ownership, that can be taken. So all these things are powers of a controller when the post examiner reports. So what I did is I summarized section 12 to 21 in few slides, important points. Once the patent application is submitted, it will be published and then it goes to examiner. Examiner has to give his report, and then patent controller will be having powers to grant the patent or revoke or ask for any information or can set up an inquiry. This is all about patent examination and publication part. Okay, so I have reproduced the section 12 to 21 here. So section 12 deals with the examination of application. So once the patent examination application received, the patent controller can provide or refer it to a examiner. Examiner will review and provide the detailed report. These 4 points we discussed earlier. So you will provide all the documents are in accordance with the requirements of this act. Subject matter is lawful grounds, and it is he has done investigation under section 13. All the reports will be published, and any other matters it will be given there. Right? Section 13 is all about researching by the examiner. He should see all the previous publications, earlier claims, everything, and then he has to make a report. So section 13 talks about that. Section 14 talks about consideration of report of examiner by the controller. Once the control report is submitted by examiner to controller, so controller can accept it. This also again we discussed, or he can refuse it. So examiner once submits the report, controller can refuse it or controller can accept it, or if controller feels that there are multiple inventions, then he can ask for division of the application, or in case if he feels everything is fine, then he can grant the patent. Okay, all these things are discussed in section 19 up to 20. If they, in case of infringement, you can go for set up a inquiry. All the sections I have reproduced it, but summary explanation I already provided earlier. Fine, guys. So with this, I'm concluding my discussion on examination and application. And in the next video, we will discuss about grounds of opposition. Once the application is made available for a public review, public can give their oppositions as per section 25. This section 25 clearly calls out what are the objections which public can raise on the publication. Okay, thank you guys. We will connect again to discuss further on patent processes. Thank you. And don't forget to subscribe our channel, Parva Media. Please share it with your friends and make it as a big team for uh, better learning. Thank you so much.